let's get started. As Kirsten already said, I have titled this presentation "From Regulation to Implementation: Mastering the EU AI Act in the Energy Industry in a Practical Way." And so this is what we'll try to do here. So I have structured the agenda of today in 4 sections. Want to start with a brief overview of the AI Act, what it actually regulates, what the logic of the regulation is, and then of course speak of the current challenges for the implementation, particularly of the high risk requirements in the energy sector, as I think that in the energy sector this is what probably creates most trouble, what is most discussed on, where there's the most unclarity. So it probably is worth concentrating on this. Then, quite current matter, I want also to take a brief look on the AI Act Omnibus simplification process, and particularly the leak of the working draft we have already seen from the European Commission. So for those of you who have not heard about it, the European Commission is planning to simplify several digital acts, including the AI Act, and make some changes to that. So and it will publish a first proposal next week. And last but not least, we also want to take a look on actually a practical implementation guidance that is out there and which could help you, or like companies in the energy sector in general, to become compliant with the AI Act, or further navigate actually what the AI Act requires. With that, I want to get right into it and start with actually taking a look at what really is the AI Act about. So first, of course, it's maybe important to clarify what does the AI Act really regulate. And so the AI Act really regulates 2 different things. It regulates AI systems on the one side, and then it regulates also those so-called general purpose AI models, so like the technology that is behind of many of the AI applications we currently see in the market. But probably more important for now for the energy industry is this term of the AI systems that has also a definition I brought with me, around 5, I would say 5, some say 5, 6 or 7, depending on what you count, essential characteristics. According to this definition, an AI system is something machine-based. That's the first one. Then secondly, it is something that operates with varying level of autonomy. Thirdly, it may exhibit adaptiveness after deployment. And then fourthly, for explicit or implicit objectives, it can infer, so actually conclude something from the input it receives. And then fifthly, it actually generates outputs such as predictions, content, recommendations, and the like, and can influence physical or virtual environment. This is actually very much compatible with the OECD definition that was intentionally chosen here. However, of course, this does not answer all questions on the regard whether the system we're looking at actually is AI according to the AI Act. So the Commission actually published a further guideline, which I have also linked here in the presentation. Maybe worth to take a deeper look into this. So having said that, I want to get actually into the regulatory structure, particularly of the AI system part. So many of you have maybe already seen this sort of famous risk pyramid that basically reflects the approach of regulating AI based on its risk. So there are 4 categories of risk in the AI Act. There's minimal risk, so this encompasses many AI systems, for example, I don't know, spam filters or the like, where there are no mandatory, no sort of obligations, no mandatory requirements, just voluntary guidelines that are encouraged. Then there is a section of limited risks. So this includes generative AI systems, for example. Mostly AI systems that interact with humans, and where we have mostly transparency obligations. And then there's this third category, most discussed, which is high risk. This is where the most comprehensive, extensive requirements are actually imposed on the providers and the deployers of those systems, and where we currently see the greatest uncertainty. And then there's the fourth, basically the risk category, which is unacceptable risks. So this includes all the practice data already provided since February of this year, for example, AI scoring systems, which you would, for example, find in China. This is already now forbidden in the European Union. And then, as already said, we have this whole different sort of branch of a regulatory object, and this is a general purpose AI in the AI Act. However, I do not want to further focus here on this because I think it's just not probably directly relevant to the energy sector, the specific requirements there. Having said that, I want to get a little bit deeper into really what counts as a high-risk system. So here the AI Act actually has two different pools of high-risk systems. The first one is the systems that are actually basically already sort of regulated under an existing new legislative framework act, for example, in the machinery or the medical device area. And it has basically like two unnecessary conditions for being regulated in there, which is that you are an AI system that is a safety component or a product itself that falls under one of these aforementioned acts, for example, machinery, medical device, but also like automotive systems fall under these. And then secondly, you also have to undergo an external conformity assessment according to that very act. So if this is both fulfilled, you're also a high-risk system according to the AI Act. Just to let you know, even though like probably most systems relevant for the energy sector do not fall into this pool. However, this new pool that is particularly relevant to the energy sector is this pool of systems that includes the use cases specified under Annex 3. And in there is critical infrastructure, which also includes many use cases in the energy sector, but also the use case area of employment, workers management, and access to self-employment, where also systems are, there are many high-risk systems. All right. With that, I want to go even one layer further and directly look at these use cases in the energy sector that classify as high risk according to the AI Act. So in Annex 3, it says that AI systems intended to be used as safety components, so this very important key term here, in the management and operation of critical digital infrastructure, road traffic, or in the supply of water, gas, heating, or electricity are usually considered high risk. However, this is not the only use case area relevant to the energy sector, but also employment, workers management, and access to self-employment probably is relevant because it's sort of relevant to all sectors. And there it is specified that AI systems intended to be used for the recruitment or selection of natural persons, in particular to place targeted job advertisements, to analyze and filter job applications, and to evaluate candidates. And then there's the second sort of sub category, which is AI systems intended to be used to make decisions affecting terms of work-related relationships, the promotion or termination of work-related contractual relationships, to allocate tasks based on individual behavior or personal traits or characteristics, and or to monitor and evaluate the performance and behavior of persons in such relationships. So this is all the basically specific use case or sub-use case areas that are usually considered high risk. I say usually because not everything that is AI in this particular use case area is necessarily high risk, because there's an additional filter. And that filter says you're only high risk if you significantly influence the outcome of a decision-making process. And then it clarifies basically like vice versa what does not count as significantly influencing the outcome of a decision-making process. This is here the criteria on the right-hand side. If you fulfill as an AI system, you fall under one of these, you just need to fall under one, not several, then you're actually not high risk, even if you are an AI system in one of the listed use case areas. And that is if the AI system is only intended to perform a narrowly defined procedural task, if the AI system is intended to improve the outcome of a previously completed human activity, if the AI system is intended to detect decision patterns or deviations from previous decision patterns, or if the AI system is intended to carry out a preparatory task for an assessment. In all these cases, it's not high risk, even though it is used in one of these use case areas listed before. Then there's one, to make matters even a little more complicated, there's one more exception from the exception, basically, and that is in the case of profiling of natural persons. It's always considered high-risk AI. Okay, having established what is actually high-risk AI, we want to also take a look, of course, what it means to be high-risk AI. And that is, there are actually obligations for both the providers of such high-risk AI systems and the deployers. So for providers, they have to make sure their AI systems have risk management. They have to have data management and data governance. Make sure that data sets used in the high-risk system are usually done fair, unbiased, for example. Then there are obligations on technical documentation, on logging, transparency and reporting obligations to then like deployers, but also of course to the legal authorities. Then they have to make sure that there is the possibility to install human oversight over these systems. Then these systems need to be robust. They need to have cybersecurity and accuracy. And there also needs to be a quality management system. So this is actually quite a comprehensive list, and this will be further specified through a standardization process. I will talk about this in a minute. But first I want to also take a look at the obligations for deployers of those systems. So of course this is applies to a lot more companies. So this is the obligations there is that to use the AI system in accordance with the instructions of use, to actually have the human oversight over the systems, then to only use representative input data wherever possible. So there again, this matter of using unbiased, fair data comes into play. Then there's an obligation to monitor high-risk systems during operation, then inform the providers in case of incidents, and also in archiving of automatically generated logs. Particularly also relevant for like any sort of serious incidents that might happen. Okay, with that, I want to also take a look at the timeline. To have maybe a broader overview, what are different components of the AI Act and when they apply. So already now applicable are the provided practices. So like several AI systems are already now provided since February. We have the AI literacy obligations in place that all the deployers and providers of AI systems have to have like a minimum competency. Then since August of this year, the requirements for the GPI models actually apply, even though there's a grace period for sanctions connected with this. So only from August next year, there will be fines possible. And then, very interestingly, the 2nd of August of this year was also the deadline for the designation of national authorities, as the AI Act has to really also be implemented in every member state, right? The member states have to establish the basically regulatory infrastructure to make market surveillance and notification infrastructure. However, almost all member states are late on this, Germany as well. We have not we have not the national implementation law passed yet. We expect that for December or beginning of next year. And then, very importantly, of course, next year the high risk requirements for Annex 3, that means also for the energy sector, apply, and also transparency obligations for generative AI systems. And then the year after, we have the rest of the high risk systems having to have be compliant with the AI Act. And with that, I think we already have an overview of what the AI Act really is about. And with that, I want to now go actually in the actual challenges we particularly observe in the energy sector. So I think there are just uncertainties in general around high-risk systems in the energy sector as in many other sectors. I think in the energy sector, what particularly troubles company is this notion of the safety component, as I already mentioned, right? What really counts as a safety component. For example, if you have an AI-controlled drone that is used for detection of any sort of impairments on your, I don't know, energy platforms, is that then a safety component? Because it may trigger human action to repair something that is in the end critical to the energy supply. This is not finally clear, and we will need further guidance on this. Similar issues are apparent on division of responsibilities among authorities. For example, when there's cross-national development and deployment, what authority is actually responsible for what. And also, of course, this overarching issue how to treat AI agents when it's not clear. There's not only one use case. So, and in all these issues, we expect then, or basically on the high risk classification issue, we expect further guidance from the Commission in the first quarter of next year. And then on more general questions on the high risk requirements, we expect guidance in the second quarter of next year. We could, of course, look very eagerly on getting some clarity there. And then another issue that I think that is as pressing for the energy industry as it is for the other high-risk sectors is, of course, the lack of harmonized standards for the implementation of the high-risk requirements. Maybe as a quick explanation, so right, the AI Act has only basically sort of high-level formulations in it what high-risk systems need to be doing, what requirements they need to fulfill, and the technical specification of these requirements is usually done, or in this case done through a European standardization process in which industry is also taking part. And this process is just a lot delayed, which of course creates major trouble for the implementation. So the timeline actually says that or the current planning of this standardization committee is that the harmonized European standards on all the different AI Act high risk requirements will not be published before mid to late 2026. It was actually for a long time rather late 2026. Now they made some suggestions how to accelerate the process. However, this might actually then in the end cause a little downgrade on quality. So we also take issue with that. But this taking aside, we do not expect them at least before mid 2026. And after that, companies still have to implement these harmonized European standards, right? So and in the past, companies needed at least 12 months to implement comparable standards. In many cases, longer, and the AI Act is particularly complex to implement. So we calculate with rather 24 months. So with that, the harmonized European standards on these high risk requirements would be probably only widely implemented by mid 2027 to late 2028 at least, according to our current estimates. And this is of course a major problem with the high risk requirements already start applying by next year. And maybe to also make this clear, why are the harmonized European standards so important? Because, I mean, in theory, you can just implement the high risk requirements. You don't need the harmonized European standards. However, practically, only the harmonized European standards really provide you the legal certainty that what you do to comply with the law is actually sufficient, right? Otherwise, you might always have like residual concerns. Is this really sufficient, right? In case of like a trial, does this actually stand up? But if you follow actually these harmonized European standards, you get this so-called presumption of conformity. That means like if you just follow the standard, you automatically complied with the law. So this is why it is very helpful for very many companies, and we're really urgently expecting this, but it's such a big problem because they are delayed. And to give you a little more perspective on why they are delayed, it's just because it is a consensus-based process to develop these, and there have been just very complex discussion process underway. We also have it was not possible to use or reference and integrate internationally existing standards as much as we would probably hope for as industry, because the European Commission judges many of the international standards, for example, on quality management or risk management, to be not really compatible with what the IAC requires. And then like simultaneously, many experts are judging really the quality of the documents to be insufficient currently. And this just delays the discussions. And again, to make clear what this delay would mean, it is just ongoing uncertainty for high risk providers how to comply with this law. We see, of course, then delays and high costs due to missed developments in the compliance build up. And in the worst case, companies hesitate and abandon plans for investments in high risk AI systems, which then of course creates just innovation losses and economic value. And that's why we as industry, a digital association representing many of the industrial players there, are heavily favoring a postponement of the applicability of the high risk requirements by at least 24 months to allow for sufficiently high quality standards available in time. With that, I actually want to directly lead over to really the process currently we see on the European level that is particularly deciding over these questions: what changes can be made to the IAC, what can be done to simplify the IAC to make it better operable. So this is the so-called digital omnibus process. It includes more than just the IAC, also GDPR, for example, Data Act, other data laws. And we expect a first proposal of the European Commission next week, actually. So it's like really current matter. And then after that, we will go through the regular European legislative process. So Parliament will form a position, Council will form a position, and in the end, we probably have trilogue negotiations. Of course, the proposal of the European Commission is already quite directive. There has already been a leak of a working draft, and that I wanted to actually show you or present the most important points, because I think several of them are actually quite relevant to the energy sector. That is, first of all, they plan a removal of the database registration for certain high risk AI systems that fall out of scope. I remember, not all use cases under Annex 3, so also under the energy sector, are really high risk if they do not significantly impact the outcome of the decision. However, so far, all AI use cases would need to be registered in a European database, which could be quite effortful. So we also advocated to have this removed. And so far the Commission seems to share our opinion on this, which was a good sign. Then also there's removal of the mandatory template from post-market monitoring. This was also something we really advocated for, because it created just too little flexibility to adapt to company and sector-specific circumstances. So we rather want to have like a voluntary guideline there. Then the EU Commission is actually wanting to make the literacy provisions into a voluntary encouragement, basically, and only provide an obligation on member states to offer guidance on literacy. So this would be a major change, right? Currently, there is this obligation in the law, and it's actually already active. And just because there was so much backlash that companies didn't know how to implement this, that the European Commission now says, okay, we actually, first of all, we wanted to have this rather as an innovation accelerating instrument, and it's so far not working out. So we remove the obligation. So I think this is also something positive that is considered. Then we have a possibility to launch regulatory sandbags at the EU level. In addition, maybe a minor point here, and there are a few exemptions and privileges that are actually now extended to small and mid-cap companies that were previously just there for micro companies. So, and this includes on technical documentation and quality management. And there's also some clarification on the interplay with the Cyber Resilience Act. I wanted to leave you with that. There are more changes. I think those are, if I looked correctly, the most important discussed for the energy sector. However, what has not been decided upon, what is most important from our view, is of course the question on the timeline. However, there is a placeholder already in the working draft of the leak. So it's likely the Commission will make a decision on this. We hear they could come around to propose a 1-year extension of the high risk requirements. It's not finally decided yet. There's some news papers reporting on this. But yeah, we of course very keen to see what is decided here, because this is so major currently. Another thing that has not been mentioned to our frustration in the proposal is that there is no Annex 1 merger. I think this might be not directly relevant to the energy industry, but maybe interesting to have heard of this. We strongly called for having this legislative frameworks under Annex 1A, so this includes machinery and medicine, to be merged with Annex 1B, which would mean that the AI Act does not directly apply, but these sector acts are individually changed in accordance with the AI Act, which would prevent all these inconsistencies from happening that we currently see between medical device directive and the AI Act and so on. So unfortunately, no changes expected here. And we will also so far not see any high risk clarification on the high risk classification or distribution of this responsibility. Probably the European Commission just sticks with clarifying this in guidelines. Yeah, so much on that. And just now, very briefly, I want to also make you aware what offers are out there in the market to really help you comply with the AI Act. So there are by now several made by institutional actors, but also by digital associations such as us. So there's this AI service desk by the AI office itself that also has a possibility for stakeholders to submit queries about the AI Act and receive tailored feedback. So this is maybe something really interesting to have in mind. And also it has a single information platform with an AI Explorer, compliance checker, FAQs, and a repository of all the resources. So all the guidelines compiled together. So maybe helpful to check out. I think this was newly launched this summer. And then there's also equivalent on the national level, right, by the Bundesnetzagentur, our central market surveillance authority that will be also in charge of many aspects of national market surveillance of high risk systems and so on in Germany. And yeah, this one is in German language. And it has also some guideline on the implementation of Article 4 on AI literacy, and maybe also worth checking out. However, as we've just said, it's currently under discussion whether at least the obligation is taken out of the AI Act. And then, last but not least, I also wanted to introduce you to our implementation guideline. We also developed one, I think also a lot earlier than the AI Office and the Bundesnetzagentur, so already last year. Now, in November, we brought this out, a 230-page document featuring basically a comprehensive step-by-step guide for placing and operating AI systems on the market in the European Union. It's available in German, and it provides arguably a more detailed and practical guidance than the KI Kompass by the BNetzA, and arguably it's more process-oriented and practical compared to the resources offered by the AI Office. And it also includes concrete examples and edge cases for better understanding. And then maybe as a background, it was really developed by 40 experts within our Bitkom network, so many legal experts, but also technical experts. And this current version is from 2024, but we're just working on an update that also includes all the new guidelines on AI definition, GPI models, standardization, provided practice, and deepfakes. Yeah, there will be a major update soonish. And yeah, I also left the link to that here. Yeah, and maybe also interesting to have in mind, other than the 230-page document that is, I think, well structured as a step-by-step guide, we also have like an online click-through tool with which you can basically go through the compliance journey yourself and hopefully provide some very hands-on practical advice. Yeah, and with that, I think I'm at time and the end of my presentation. Yeah, I hope I gave you some helpful insights, and then now I'm interested in your questions and remarks on this.
Yeah, thank you, Yannis, for the great presentation and the great structure of the presentation. I think we can all agree that you made the AI Act a bit more structured in your presentation, and everybody could follow it. We see the AI Act entails so many aspects and exceptions from exceptions. And of course, this triggers multiple question marks, of course. And regarding the complexity, so the Draghi report last year that was published concluded that Europe is losing the technology battle against China and the US, and it called for more innovation and risk taking. So with the AI Act, are we missing the forest for the trees? And is Europe going to regulate itself to death, so to speak?
I mean, I would be not that pessimistic for now. So there are clearly improvements necessary on the AI Act. We advocate for them. We think we need particularly more time on the high risk requirements to really work out workable, practical standards. And also some things are maybe redundant and so on. But I mean, there is also this promise of just providing reliable standards, minimum standards for safety that could all actually, in the best case, accelerate AI uptake because it creates trust. And we see basically these two sides also in all the surveys we actually conduct, that it's currently split half between all German companies, whether they think the AI Act benefits companies or benefits German economy more, or it harms it more. And so I think there's just this strong call for the European lawmakers now to make it more practical, to make it more feasible, to make it more in the service of innovation and not hindering it. But I think this fight is not lost yet.
Yeah, thank you for being such an optimist in this case. I think we need that a lot more. And I would say that to summarize maybe your answer, it sounds a bit like that we should be more optimistic on the one hand, but also should not lose the sight for the goal of the AI Act, namely to make things easily understandable. So the first thing I think which is also, I think, part of that question, is that people see the AI Act and are completely lost there because there are so many regulations in there and so many definitions. But the goal is to actually simplify it. Yeah, as I said, another aspect of is of course the many definitions of the AI Act, and regarding the unclear division of responsibilities for AI agents, especially, how would you classify a meta agent or validator agent? Specifically, if an agent's sole purpose is to test and validate other potentially high risk AI agents, acting only as a QA tool, could that validator agent itself also be classified as a high risk system?
It just seems like a very easy starter question. Yeah, and to be fair, this is really hard for me to answer right now. I can just yeah, I recommend you to like check out maybe the AI service desk resources the AI office provides, and post that particular questions to them. And we hope that we get further guidance on AI agents because right, it's such an rising topic, rising importance. We hope we get further guidance on this next year. So it's yeah, so far I think not easy to answer question, but definitely one that only will become more important.
Mm. Yeah, it's of course very important to say here that those specific things are part of the AI Act, but actually they need time to develop, as I hear from your answer. And but we will get clarity, I think. In the near future, as you said. A question came in regarding regulatory news deviating a bit from the AI Act. So, could you maybe speak to the consequence of the failed ALD for the energy sector, as now regulations seem to be past sector specific? So, can you speak to the current status here, maybe?
The failed what? Sorry.
AILD.
Yeah, so like I'm not so a so this is AI liability directives, I think.
Yes.
So yeah, I think we were so we as a digital association were really not in favor of such an additional AI liability directive because yeah, we just I think we should first just make the AI Act work, not split focus and resources here. Learn from experience and not like dive into like the next regulatory endeavor. So yeah, at least to my members, it was not something we supported at this point, and so we were pleased with the removal by the European Commission this year. That is what I can say from our side.
Yeah. Um, Yeah, thank you, first of all. And another question came in, especially for seeing patterns in AI. So, how can we determine whether the use of an AI or pattern recognition system to optimize an energy system, such as a heating power plant in a district heating network, qualifies as high risk? So, again, a question of definition. For
Mm.
example, using temperature forecasts for operational planning and energy generation control. So, where can we find guidelines to better understand this classification in energy production contexts? So, it's of course a very important question because AI, especially in heating power plants, is used at the moment. So, it will be of great importance for many companies here.
Yeah, I agree that this is a very pressing question. So like classification in general is a pressing question. So right, as said, I have just uh, put up this slide. The Commission is actually planning to publish their guidance on the high risk classification that should hopefully make fully clear also this particular question or answer this particular questions clearly in the first quarter of 2026. They have already conducted this comprehensive consultation this summer. And so they now have hopefully industry opinion on this, and now we are awaiting their proposal and hope it suffices our needs there. So yeah, at this point I think I can just mostly recommend to be a little more patient, even though I know this a huge problem, particularly with the pressing timelines, right? I mean, if the high risk requirement would not be, and so the implementation timeline would not be delayed or extended, then we would have very little time between having full clarity what really is high risk, what all the high risk obligations entail, and actually then the law applying, and that's why we are advocating so heavily for an extension of the deadlines.
Yeah, thank you for clarifying that. And I think that patience is here a great keyword. Maybe reducing a bit the complexity of the AI Act. So, if you would have to summarize the role of the AI Act for the energy system in one word, what would it be and why?
I think it would go with indeterminate, just because, right? This is this theme, unfortunately, also of this presentation. There are just open questions a lot on definitions, right? On classifications, on the standards. So potentially, if these were all in the end answered, we could, I think, in the medium to long term, really see this positive effect on trust in AI systems, and therefore this could accelerate uptake. But currently, it's just like imposing major struggles, a lot of legal costs, and a lot of uncertainty how this will all turn out. I think final judgment is too early for final judgment. I go with indeterminate at this point.